Chairman Dennis, you're recognized on item number 17, House Bill 2835.
Thank you, Mr. Chairman. This bill expands the definition of pecuniary benefit in the bribery statute 3916-101 to include appointment to a membership, leadership, or chairmanship position on any committee, board, or other governmental body. And I would move passage.
There's a motion and a second. Are there any amendments?
There is one amendment, I believe, in the package, but I had that drafted to look at, but I don't think I'm going to pursue it. So
there's no intended amendments?
No intended amendment.
Representative Stewart, you're recognized.
Yes, Chairman Dennis, I was just wondering what the motivation is behind this. I mean, is there a particular person, a particular incident or situation that this bill is targeted at, or?
Well, the conduct that I would be proposing that we prohibit is the basically buying or selling of a membership on a board or a chairmanship or leadership position on a board or a committee in exchange for a vote. Our state bribery statute requires a pecuniary benefit. There is no definition in the statute for what pecuniary benefit is. The, I guess, common definition, the Webster's version of the definition, is some type of financial benefit. The federal bribery statute is quite a bit broader. The federal bribery statute says anything of value. It's my feeling that a position on a board is essentially something of value. If it wasn't, I don't think we'd have nearly as much wrangling over them in this body and in other bodies, in other local governments across the state. So my concern is selling those positions in exchange for a vote for something. In my mind, it's no different than selling a board membership or a chairmanship for $1,000. Or it's no different than me going to a judge and telling a judge I'm going to put him on some committee if he'll decide this case my way. Our judges are judges of the facts and of specific cases, but we're the judges of policy.
Here's the only concern I have. So let me make sure I understand how you think this would apply. Somebody's running for an office. That office appoints members to a board, the Solid Waste Management Board or whatever. If they appoint, I'm trying to think how this would play out, a person is elected, an appointment is made, and then there's some sort of legal action that's taken which is favorable to I guess the person appointed. That would then creates a bribery case.
You'd have to have the quid pro quo. You'd have to have the actual trading. You vote for me for this position, I will appoint you to this board position on the solid waste board or whatever board it is. But you have to have a quid pro quo.
I guess my concern is it is unusual for a politician to receive money from most private citizens, and therefore when a politician receives money from a private citizen for something other than direct work, and then there is a vote taken, you raises an inference that there's a concern outside of the specific campaign finance laws, which are very strict. Whereas there are all sorts of instances where people are elected to things and they also have a hand in appointing boards. I just worry that, I'm trying to figure out what would be the break on this thing. Can any disgruntled person who's beaten in an election essentially swear out a warrant on somebody as long as he's appointed somebody to a board? It seems like it opens up quite an array of possibilities for abuse. How is somebody supposed to show that there's no quid pro quo?
Well, the burden's not on the defendant to show there's no quid pro quo. The burden's going to be on the state district attorney to prove beyond a reasonable doubt that there was a quid pro quo. So I don't think there's any more particular incentive for misuse by someone with ill intent than there is in the bribery statute as it is. We take, politicians take all kinds of campaign contributions, and then we wind up voting on issues that may or may not have affect those entities that have made those campaign contributions or the individuals. But a disgruntled person can't just come in and say that was a quid pro quo. You're going to have to be able to prove that beyond a reasonable doubt if you're prosecuting a criminal case. Is it a little bit of a murkier standard? Probably, but your DA is still going to have to prove that beyond a reasonable doubt that a quid pro quo occurred.
Because, am I remembering right, I think our bribery statute has a specific safe harbor for our entire campaign finance system. Thus, if something is done, and I may be wrong, I'm not an expert in this area of law, but my understanding is that essentially if something is done pursuant to our campaign finance system, it is excluded from, it is by definition outside of our bribery statute. What I'm worried about is, politics is a somewhat competitive situation. People get heated and people get mad at each other, and I think we've seen in other states instances, we've seen in other states recent instances where people were accused of bribery or violating the federal bribery statute, and I know that in the case of a woman, I think in Illinois or Minnesota, you had I wish I could state the specifics, but I'm sure you're familiar with this situation, and I think it was Minnesota where the prosecution was deemed to be so outrageous and baseless that the Court of Appeals actually stepped in and summarily set aside the conviction, if I'm remembering this correctly. And then we have the governor of Alabama, whose prosecution is viewed as, put it mildly, highly suspect. I just worry that we're opening up a can of worms here, and if we've made it since the days of Andrew Jackson to today without doing this, why do we suddenly need to change the bribery statutes? I mean, they've been good for us up to this point.
Well, the argument that why change it now as opposed to before, we change statutes all the time. We've got 4,000 bills filed this year, of which maybe a quarter of them will go in and change some statute or another. I feel the times warrant it. I've not been in the legislature 20 years. I've been there as long as you have, and it's my feeling. It was my feeling before I was elected, and it's my feeling now that this is appropriate and needed. So that's why I'm running it, is because I feel it's necessary and would be helpful for good government. Now, going to the other issue, there is a specific exception in the bribery statute, a specific defense that the money that you receive in exchange for your vote is a lawful campaign contribution. So, in '89, when the Criminal Reform Act was implemented, they put in a specific exception that you can sell your vote for a campaign contribution. Now, the feds don't like that. I think that's a violation of the federal bribery statute, but the state code says it's okay. That's a problem to me, and I've not addressed that in this bill, but that's something I want to look at in the future. But this one is more to the issue at hand, and the concerns I have are about selling board positions, selling leadership positions on those boards, or selling them for a vote.
And I guess here's my question. I think actually the way you describe the campaign finance exception is not, I don't agree with your characterization. I don't think Tennessee has said we want to go light on people who are participating in the campaign finance process. I think what the motivation of this body behind passing that law was to say that an accusation of bribery is a very momentous and career-ending accusation, and therefore we want a law that provides clarity, and we don't want anybody to be able to just wander in and say, this person took a campaign contribution and I want to drum up a bribery charge. I'm a little worried. I guess obviously you're coming to this for all the right reasons, but I have to say I'm worried that this makes a clear criminal statute that has been operating very effectively for many years much more murky and subject to all sorts, to abuse, and so I'm opposed to it, although I appreciate what you're trying to do.
Vice Chairman Lundberg.
Thank you, Mr. Chairman. I like the bill. I like the intention of where it's going. There are a few things that I'd like to pull together just because I don't have some of the background, and I wondered if the sponsor would mind rolling this for 1 week.
I'd be glad to. If the committee sees fit to roll it for a week, I'm fine with that. I'd ask for a committee roll, but
Mr. Chair, that would be my request.